Hello and welcome to this Advent IM webinar on the Data Use and Access Act. My name is Mike Gillespie. I'm the Chief Executive here at Advent IM, and I'm going to be walking you through the key changes and give you some insight of the things that you need to change with your internal processes in order to prepare for and ultimately comply with this new piece of legislation. The idea of this webinar is to take the policy and turn it into real life practice to help you to make sense of what the changes are, to understand how that's going to impact your organization, and to help you to prepare for the changes that are going to come. Coming up, therefore, we'll be looking at the key changes introduced by the Act, exploring its impact on organizations, and ultimately identifying practical next steps for compliance and give you an insight into some key best practice, some of which you can introduce immediately and some of which, as we'll see, there's a transition period for. So let's start by looking at the journey itself. Obviously, at the far left of our road really is the UK GDPR, the legislation that was introduced post the introduction of the EU GDPR back in 2018. Along the subsequent years, there was a lot of disquiet, argument, discussion, debate about whether this legislation was genuinely fit for purpose. Many argued that it was cumbersome, unwieldy, that it put unnecessary burdens on organisations. Now, I'm going to go out on a limb here and say some of those arguments were being put forward by organisations who wanted to do things that were less in the interest of the data subject than it was for themselves. However, there were some key issues, largely because of the way that EU legislation and UK legislation tend to butt up against each other. In the main, EU legislation works on the basis of that which is not expressly permitted should be forbidden. Here in the UK, we tend to take a more pragmatic approach of saying, if it isn't forbidden, then you can assume that it's allowed. So you can see that there's a conflict there culturally in the way the legislation is produced. Equally, there's a lot of stuff in the legislation that some organisations adopted way beyond the necessary provisions, and in doing so, at times, bogged themselves down in bureaucracy. And finally, of course, with anything like this, and I think the biggest change that impacted on a lot of organisations was the removal of the fee for a subject access request, which opened the floodgates for a large number of additional requests, many of which became excessive, complex, and resulted in burdens and bureaucracy with organisations. So under the last Conservative government, there was growing pressure to make changes to our data laws. The complexity here being that we wanted to make those changes whilst also maintaining our adequacy with the EU. Adequacy meaning that we are considered to be an adequate state with adequate protections for data protection and therefore could continue to have free movement of data around the EU. So the Conservatives introduced a piece of legislation called the Data Protection and Digital Information Bill. This went through a number of iterations, a number of challenges, and ultimately in the run-up to the election failed to make it over the finish line and was therefore shelved. In 2024, however, Labour reintroduced the bill, but under the name the Data Use and Access Bill, with a much tighter scope, limited amount of changes, or more limited amount of changes than the Data Protection and Digital Information Bill introduced, and getting rid of some of the more contentious elements that had privacy advocates and the ICO themselves concerned about the legislation. This moved quite rapidly for UK legislation through the various stages, and then in June 2025 received royal assent. So in effect, the Data Use and Access Bill is now the Data Use and Access Act and is now UK law. It's important to recognise that this is not a new Data Protection Act. It has not replaced the Data Protection Act, and it has not replaced UK GDPR. But what it does do is make significant modifications to the existing legislation. So, what happens after royal assent? Well, immediately we are in a position whereby some of those changes can be actioned straight away. So immediately the provisions around proportional SAR searches, the ability to reject SARs on the basis of them being excessive or being able to reject them because of large numbers of repeat SARs, those provisions have come into effect immediately. And so we can start to introduce those changes to the benefit of our organisation straight away. More on that later. By August 2025, there will be initial enforcement powers. The Information Commissioner's Office will transition to the Information Commissioner, and we will have new enforcement powers around information and document notices coming into force. Then effectively, within 12 months of royal assent, so just under a year from now, all of the remaining provisions via secondary legislation will become extant. So we must be able to introduce all of those changes into our organisation by then, because that will be the end of the transition period. And from that point forward, effectively the new legislation is in place. So let's have a look at some of the key changes that have been made then. And the first one we're going to look at is automated decision making. The key changes here are that the Act allows provisions for more leniency around when automated decision making can be made. So things like credit checking, job references, recruitment searches, CV screening, and so on. Really, this is low impact use of automated decision making. And what it says is that even if you're using automated decision making, you should still ensure that you allow the data subject the opportunity to object, to be appropriately informed, and to request for human intervention. So somebody should be able to look at that automated decision and make sure that it stands up. So it's not carte blanche to be able to go off and do automated decision making all over the place, but there's more leeway in how we can use ADM going forward. The second one is around digital verification services. The second area is around digital verification services. So this is going to be particularly useful for people wanting to use digital verification, digital ID if you like, in areas like fintech, HR, background checking, and a whole range of other areas. It's also going to be key to the government's future digital identity programme, which will allow us to authenticate and engage with government in a more digital manner. Don't have a lot of time here today to delve more into that, but if that's an area that you have a lot of interest in, then please do let us know and we'll do a future webinar with a deeper dive on it. The third one is around cookies. How many of us have not been plagued by the cookie pop-up banner? How many of us find ourselves tearing our hair out that even within the same organization, multiple refreshes of a web page take us back to the same pop-up? This is not going to result in us being, This is not going to result in organizations being able to ride roughshod over our privacy, however. What it does do is allow for more leniency around cookies that are absolutely necessary. So for continuity and for the third area we're going to look at is around cookies. How many of us have found ourselves plagued by those cookie pop-up banners when using websites? Even even moving around multiple sites within a website. No, that's not right, is it? Even moving around multiple pages within a website, we can find ourselves being returned to that cookie pop-up banner time and time again. The idea is to streamline this process somewhat. The idea is not to allow organizations to ride roughshod over our privacy, however, and cookies remains an important focus of this legislation. But what it does do is allow some leniency around the use of cookies that are absolutely necessary. So for continuity and for analytics and for performance and things like that. It doesn't mean that we're all now going to be obliviously served up tracking cookies. What it does do, though, more importantly, is align the penalties for the misuse of cookies to GDPR. So until now, the penalties under the Privacy and Electronic Communication Regulations, PECR, which largely governs electronic marketing, the penalties for that were much lower than those allowed under GDPR. This legislation modifies that, and now PECR penalties are exactly the same as they are under GDPR. So maybe organizations become a little bit more focused on the importance of cookies and the use of cookies and the transparency of the use of cookies than they previously have been. Especially those organizations who seem to insist on serving up an endless list of vendors and other organizations who claim to be using legitimate interest as their reason for using cookies. We shall see, eh? The next one, and a really important one, is the new use of recognized legitimate interests. Now, this is a really important change to the legislation because what it allows for is the use of legitimate interest without the need to do a balancing act in certain circumstances, not in all circumstances, and it's important to note that. The really big change to this, however, is the increased capability of the use of legitimate interest within the public sector. Previously, legitimate interest was extremely limited when used by public sector organizations. The legislation now allows for the use of legitimate interest without the need to do a complex balancing act or complete excessive documentation for purposes of things like public security, crime prevention, safeguarding, protecting vulnerable individuals, for national security purposes, and for responding to emergencies. So this will have a big impact on organizations like local authorities, emergency services, and regulatory agencies. This is not, again, an open door to use legitimate interest for everything. And the legislation still says that you must not use legitimate interest if the activity you're carrying out is for the exercising of your official public tasks or powers. So tasks being carried out in the public interest or under official authority. In these cases, you must continue to use the lawful basis public task as defined under Article 6(1)(e) of the UK GDPR. So this is a really useful way of highlighting the fact that this is not a replacement for the legislation, but a modification to the legislation. And it's important to understand how those modifications then apply to the wider text of the UK GDPR. Another area that I'm sure organisations will be very interested in is the changes around the use of subject access requests. And the first thing is the new grounds for refusing or charging for subject access requests. Organizations can now refuse or even charge a fee, a reasonable fee, for subject access requests that are considered to be vexatious, i.e. intended to disrupt operations, or excessive, That is, those that are repeated requests with little changes. Now, this replaces the previous and much narrower definition, manifestly unfounded or excessive. So in effect, delete manifestly unfounded or excessive and replace vexatious or excessive. What the legislation also does is it clarifies the timeline for 1 month for response. And what it says is that the 1 month starts from the point at which the individual's identity has been verified, not from the date at which the request is first received. So if you receive a request and you need to go back and verify the individual's identity, you don't start the clock until you have received that identity verification. It also allows us to continually stop the clock any time that we need to go back and ask for clarification, and we don't start the clock until we have that clarification back from the individual requester. Now that's really important because that makes a big difference around how we manage the timeline and the fulmination of subject access requests. It also says that organizations will have streamlined obligations for search requirements. So effectively, we no longer have to conduct extensive or disproportionate searches to comply with a request. So that means you can limit the scope of your search if it would otherwise involve excessive effort, but you must provide an explanation of that to the requester. And you cannot use the fact that you have bad information management or bad information management structure as a reason for not conducting those searches. So again, proportionality is key in all of this. There are enhanced protections around internal communications for things like legal advice, management planning, negotiations, and so on. And these can now be withheld much more easily under SAR exemptions. It's important, however, in all of this that we're still complying with the need to manage the data subjects' rights because they are fundamental rights and freedoms. And what we must be able to demonstrate to the subject is that we are still respecting those rights and freedoms. There are some significant sector-specific impacts, and so we'll have a quick run through on what we need to consider there as well. So in healthcare and public sector, it is expected that the changes to this legislation will save frontline NHS workers 1 million hours going forward. 140,000 hours annually is the expectation, mainly by reducing data handling bureaucracy. But it also introduces new standards for health and social care data interoperability. The idea with all of this is that we should be able to collect, use, and share patient data confidentially and safely in order to deliver an effective and efficient healthcare solution. It doesn't say that we can ride roughshod over their rights and freedoms, but it is designed to break down that bureaucracy that so often has held healthcare back. A more responsible and transparent use of data so that we can strengthen public trust, but also support innovation, research, improve service delivery. And in fact, there's a lot of work being done at the moment around the use of AI in healthcare, but using AI in healthcare in a legitimate and proportionate and ethical and responsible way. Expect more of this to come from future legislation like the UK AI Act as well. The new Act significantly modifies Part 3 and Part 4 of the UK Data Protection Act. The parts affecting the use of personal information by policing and intelligence services. Again, part of these changes are to reduce bureaucracy, increase effectiveness, support the reduction in manual data entry, efficient data sharing between departments within police forces, but also across police forces, whilst also enabling us to share more information effectively with the public as well. We must comply with the new safeguards that ensure responsible data use. And again, this is aligning with some of the guidance that's coming out from various digital policing strategies. If you've not read it and you're involved in policing, law enforcement, or collaborating with law enforcement, you should definitely be reading the new AI covenant that's been produced by NPCC. And you should be thinking about how that AI covenant is going to align with your data protection practices going forward. We want to be able to allow police forces to access information legitimately in a speedier fashion and share it to enable public safety, public security, safeguarding, and law enforcement. And ultimately, this will improve evidence handling and case management. As I said, it also modifies Part 4 of the Data Protection Act, that which covers off things like defence and national security. So there are clearer exemptions for national security related data processing. And this is really important because ultimately what we don't want is data protection to be seen to be holding back national security, protecting the public interest, keeping our places safe and secure. And this is really important because what we don't want is for data protection to be holding back national security, protecting our public space safe, secure, and free from crime and terrorism. So there are clarified scopes here as well for legitimate interests for defence organisations, reducing red tape and bureaucracy when it comes to data sharing and data transfers. And of course, there's that AI again. Supporting AI-driven threat analysis and logistics to meet emerging threats. And the use of automation is allowed with safeguards and oversight. Again, not enough time on this webinar to do a deep dive into defence and national security, but if you're involved in those sectors and you want to know more, please do reach out to us and we can do something specifically for you. So what are the next steps then? Well, first, I would make sure that we've done a data audit and we know what data we've got and why we've got it and what its purposes are. And we understand what lawful basis was previously being applied for that information. Start to think about updating privacy notices and consent mechanisms, especially if you're wanting to move more towards the use of legitimate interest as a lawful basis. Then we must make sure that we update our privacy notice and we communicate any changes in lawful basis to data subjects effectively. Think about training your staff on the new lawful basis. If you have teams or individuals who are handling data subject access requests, make sure that they understand what the changes are. If you don't feel confident at being able to provide that training in-house, then our training academy have training courses geared up, ready to go, that we can deliver in-house, or you can send individuals onto open courses and we will train them for you. And finally, start to monitor the ICO guidance and look for any sector-specific codes of practice that are coming out. If GDPR has taught us anything, it's that those 12 months will go by very quickly. Let's start to prepare today and not wait until the 11th hour. If you've got any questions, then please do reach out to us. You can also connect with us on our social media channels. Our YouTube channel has a lot of video content, educational content, so please do look that up. And remember, we also have our blog, we have our podcast, and we have previous webinars that you can look up as well. I've been Mike Gillespie from Advent IM. This has been a bit of a whirlwind through the Data Use and Access Act. However, if you've got any questions about it, or you want to know more, or you would like us to do a deeper dive on any of these topics, do please get in touch and we'll do it for you. Thank you very much for your time today. Take care and good luck preparing for these changes.